Everyone, Joe Gentili, it's Saraf Gentili LLP. Today I want to go through an issue that unfortunately affects some people that are going through the EB-5 process to get a green card. So EB-5 is a visa category that's available to people that make large investments in the United States, and those investments create jobs. And so one problem that they're coming across, and we're seeing this at the I-829 phase of the process, this is where you've already gotten a green card and now you're removing conditions on the green card, is that at that stage, you're required to produce documentation to USCIS to show that the money was invested where it was supposed to be, the jobs were created, so on and so forth. And the project that you're investing with usually has an obligation to provide you with the documentation to complete your petition and satisfy USCIS. And what we're seeing is that some projects are not complying, and for whatever reason, they're withholding the documentation. And this is causing a lot of problems for the applicants because they're dealing with strict deadlines to produce these documents to avoid a denial. And so if you find yourself in this situation, the one thing I'd like to really drive home is that you need to act quickly in terms of getting a lawyer to start working on getting those documents, because there are remedies and there's tools that you could use to try to force the projects to comply, but they all take time. And so you probably don't want to just go to your immigration lawyer, because most of them will not be familiar with the tools or haven't used the tools that you need to use in order to get these documents. You're going to want to go to a firm, or you're going to want to have a legal team that has some expertise and experience, not only in immigration law, but also securities law, state governance laws, like the laws governing state partnerships and state corporate law, and have experience litigating. So that said, if you got the right team in place and you're moving quickly, some of the tools that are available to you are, after looking over the applicable agreement you signed, whether it was a limited partnership agreement or an LLC agreement, you're going to want to see if you can allege that that the project made a breach of the agreement, that they've made representations to you that they're going to cooperate and provide these documents, and they're not. So you're going to want to make a demand to them saying that if you don't provide these documents, it's going to cause us irreparable harm. And irreparable harm is kind of a loaded phrase in the law, because what that really sets up is you're laying the groundwork that you're going to move for what's called the preliminary injunction, which is basically a lawsuit where you're trying to move really quickly to avoid a outcome that can't be fixed with money, that it's going to cause harm that just can't be fixed later on. So for instance, if you end up, unfortunately, worst case scenario, the 829 is denied, you end up in removal proceedings, eventually removed. That's not fixable later on. So that said, the steps over there are, you're going to want to make the demand saying that there's a breach of the agreement, that breach is causing an irreparable harm. If that doesn't do the trick, you're moving for a preliminary injunction. If that doesn't do the trick, then later on it's basically a money damages case. The other tool that may be available to you that's also very powerful, and this is really depends on the specifics of your agreement and the state laws that are applicable. So whether there was particular state laws chosen in the agreement, or you have the states of incorporation of the entities that you need to get documents from, you will be able to make what's called a books and records demand. So if you're a limited partner or a shareholder in an LLC, in most states, you have rights to demand documents related to your ownership. And so, financial records, possibly the documents that are like right on point for what you need to respond to USCIS. And you're also going to be gathering documents regarding any potential improprieties that would have happened in the project. So if that's not complied with, most states, you're allowed to sue to enforce the books and records demand. And some states even allow for fee shifting, which means that if you win the lawsuit, the other side may be forced to pay your attorney's fees. these are really powerful, and people don't like complying with these, or they certainly don't like to get sued under it, because not only are you asking at this point for the documents that are relevant to your 829, but now you're asking for documents about improprieties, which you're entitled to under a lot of state laws. And that provides you with some really strong ammunition if a suit for damages is needed later on. And projects and their attorneys, they're going to be aware of this. So this is a really strong incentive for them to help you to avoid giving that information that could be used against them later on. So as you can see, if you're in this situation, there's probably some tools that could be used to help you get the documentation that you need to satisfy USCIS, but it's important that you act quickly and you do so with the right counsel. If you have any questions, please feel free to reach out. And if this was helpful, I hope you subscribe. Thanks and have a great day. Bye.